what are we supposed to do?
Hear ye, hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning. We are here this morning on case 2018-444, the State of Ohio versus Randy Jones et al. Sitting in for Justice Stewart is Judge Beatty Blunt from the 10th District Court of Appeals. Welcome, Judge.
Thank you for having me.
For the State of Ohio, we have first arguing Mr. Miranda.
Thank you, Your Honor. Chief Justice O'Connor, may it please the court. My name is Anthony Miranda on behalf of the State of Ohio. I'll be sharing 5 minutes with the Attorney General, and I'd like to reserve 2 minutes for rebuttal, please. Trial courts have full discretion to impose prison sentences within the statutory range, and nothing in 2953.08 empowers reviewing courts to reweigh the sentencing factors. I'll like to start briefly with the plain text, although the General will speak more specifically about this, because I think it's important to note that the appellate review statute does not mention 29, 29, 11, or 12. And the 8th District in its en banc decision below recognized that fact, but nonetheless held that review of those statutes should be read into the appellate review statute. Because Ohio courts...
I ask you a question, setting aside whether an appellate court can review with that statute, do you agree that trial courts are required when imposing a sentence to consider 29, 29, 11 and 29, 29, 12 before they, as the trial court did in this case, mentioned during her sentencing.
Yes.
Okay, so if they don't do that, aren't they acting contrary to the law?
Yes.
Okay.
I agree with that. And just to finish up on the textual argument, because appellees are making the argument regarding the phrase contrary to law, but that's not actually the rationale of the lower court. So I just want to make sure the court rejects the reasoning of the lower court, which was inserting words into the statute that weren't there. But correct, the appellees argue that review is permissible under contrary to law. And in State versus Kalish, in this court's lead opinion, this court stated that sentences are not contrary to law if they are, one, within the statutory range, and two, where the trial court considered the sentencing factors. And that consideration is a binary question, did or did not consider.
Okay, I have a follow-up question to that. I reviewed the transcript, the sentencing transcript, and it appears the state of Ohio did not advocate for the sentence that was eventually imposed. The state of Ohio correctly said that what the defendants were convicted of had a presumption in favor of incarceration, and they simply advocated for a prison sentence, and they believed that the minimum would be inappropriate. However, they never advocated for a specific number. The defense was advocating for community control, but said to the judge, if you believe prison is appropriate, we're asking for the minimum. So it would seem that the state would have been satisfied with 4 or 5 years in this case, based on their representations. Can you tell me what in the record would guide the judge towards the 10-year sentence that which was eventually imposed?
Yes, so you're correct that the state didn't identify a specific number. It did advocate for a prison sentence. I would point out that the trial court in this case, which observed all the testimony and observed the witnesses, noted that this was one of the worst cases of child abuse it had ever seen. The trial court specifically stated that with respect to Carissa Jones, there was no expression of remorse throughout the trial or at sentencing. And so based on those are just two examples of what the trial court's rationale was here for imposing the 10-year sentence. But I think ultimately the question is not whether the state gets to decide what is an appropriate sentence, but how much discretion trial courts have. And this court has recognized since Foster and including Kalish that trial courts have full discretion to apply these multi-factor factors contained within 29, 29, 11, and 12. And really the only authority that appellees rely upon is this court's decision in State versus Markham. And I want to emphasize that State versus Markham did not deal with the contrary to law provision. If the court looks at the 4th District's decision in that case, it explicitly noted that the defendant conceded her sentence was not contrary to law. The question in State versus Markham was what is the standard of review? And specifically at paragraph 14, the court cited to Kalish and stated, quote, if the sentence was not contrary to law, for instance, if it fell within the statutory range, the broad discretion recognized in Foster came into play. So then when appellees cite to the later paragraph 23, we can look back to the definitions of contrary to law, and we can see that the court was not changing the definitions identified in the earlier paragraphs. So when we look at paragraph 23, the court notes that in some cases, statutory findings are not required, but it is nonetheless permissible to review those sentences for support. And that goes to the second part of that definition of contrary to law, the binary question of whether or not the trial court considered the factors. While 29, 29, 11, and 12 do not require fact-finding, it is completely appropriate for a reviewing court to determine whether or not there is support in the record for the fact that the trial court considered.
Mr. Miranda, what's our standard for reviewing that, as you describe it, a binary question?
The standard of the.
So
can you repeat that question, Your Honor?
Yeah. Yes, we look at the record to decide whether the trial court did in fact consider 11 and 12. So do we have a standard for how we look at that, as you described it, a binary question? Yes.
So in Markham, this court said in determining whether or not the trial court did or did not consider the factors, the standard is clear and convincing evidence. And that was the legal issue that was presented in that case. I believe it's a certified conflict. But what's clear is the court was not creating a distinct definition of contrary to law. It was not departing from the explanation of contrary to law that it lays out only paragraphs earlier. And I think that it's important that contrary to the law not be expanded in the way Appellee suggests, because one of the things that has been noted in this litigation is that there is no fact-finding requirement. So if this court looks at the first Jones opinion, which was ultimately vacated, but the first Jones opinion, the 8th District panel initially said it couldn't review the factors for support because there were no findings. And it initially remanded the case to the trial court to engage in fact-finding. So that is an example of how divorced from the text Appellee's interpretation gets us. It has us to a place where we're requiring trial courts to engage in fact-finding that are nowhere in the appellate review statute. I'll share the remainder of my time with the general at this time.
Chief Justice O'Connor, may it please the court. The state is correct that when a trial court considers the sentencing factors and purposes and then gives an in-range sentence, then an appellate court is without power under the .08G provision to then second guess that in-range sentence. I'd like to focus first on a statutory structure point and then touch on one of Justice Donnelly's questions. I think statutory structure is a very powerful tool of to signal meaning in this case, because if you look at .08G2, it divides appeals into two different avenues. On the one hand, in 5 specific situations, a appellate court does have the ability to revisit a trial court's determinations and decide whether the record supports them. Whereas under the G2B provision, we're talking about contrary to law appeals. I think the interpretive goal of the court in this case should be to interpret these provisions in a way that gives both meaning. And I think the threat is that if you interpret contrary to law too broadly, you're going to be simultaneously stealing meaning from the G2A provision. And I'll give an example of that. One of the 5 listed situations in G2A deals with when a trial court does not impose a prison sentence for a 1st or 2nd degree felony. And because that goes against the presumption of Ohio law, to do that, a trial court needs to find, and this is .13D, it needs to find that a non-prison sentence will adequately punish the offender, adequately protect the society, and not demean the seriousness of offense. Well, if those things sound familiar, it's because they're the exact same considerations that go into the .11 mix. So if contrary to law already folds in .11 and .12 considerations, there was absolutely no reason to include that in G2A as one of the listed scenarios. Another way of getting at this is, if you look at the defendant's briefing, they've really abandoned the plurality theory that we're reading something in to G2A, and that's for good reason. This court, when it interprets statutes, doesn't add language that isn't otherwise there. So this really does come down to contrary to law, but the problem with their theory of the case is that they have no good limiting principle for what contrary to law means. If contrary to law is really broad enough to bake in all the ingredients of .11 and .12, again, we're going to be robbing meaning from the G2A statute. Justice Donnelly's first question dealt with, well, what could be contrary to law under .11 and .12? And I agree with the state that Point 11 and point 12 contain mandatory lists of factors the court must consider, and they also contain, if you look at point 11C, prohibited factors. So I do think there is a potential to have a contrary to law sentence if a trial court either completely fails to consider a factor it was supposed to, or considers something it wasn't supposed to. But I think the important distinguishment is between that scenario and an argument that isn't about failure to complete failure to consider, but is instead about, I don't like the weight this one factor or this series of factors gives. I don't think point 11 or point 12 is an outcome specific command for any particular in-range sentence. I think one reason is the structure point. A second reason is that if you look at the language of point 12A, it's very clear that it's up to the trial court, and I'm quoting here, to determine the most effective way to comply with the purposes and principles of sentencing. I do want to be respectful of the state's rebuttal time. If there are no further questions, we ask that you reverse and specifically hold that the Jones's appeal was unreviewable under the 0.08G provision. Thank you.
Thank you. Mr. Martin.
Chief Justice O'Connor, may it please the court, John Martin on behalf of Carissa Jones and also on behalf this morning of Randy Jones. The state of Ohio is incorrect when it suggests that trial courts should have, or that Kalish recognized that trial courts should have full discretion in imposing sentences. Let's go back for a second, if we could, to 1995 and SB2. Now, before that, trial judges gave indefinite sentences, robbery, 5 to 25. So who took care of things like considering mitigating and aggravating factors or proportionality or consistency? Well, the parole board did, the executive branch did. So now SB2 comes along and says, okay, look, we don't want the executive branch to be part of that calculus anymore. We're going to handle this ourselves within the judicial branch. So SB2 says, trial courts, you're going to impose sentences. There's going to be statutory parameters in terms of minimums and maximums, but there's also going to be statutory factors that are part of the law that you should be that you have to consider in every case. And in order to make sure this works, we're going to have meaningful appellate review. And you know, that meaningful appellate review that's something that we've had for everything. There's no, or very few places where a trial judge can make a decision and not have a court of appeals look over her shoulder at the end and review that decision, albeit with some discretion, depending on the situation. But you know, the only thing that a trial court can do that's unreviewable is to acquit a defendant, and that's because of double jeopardy. So we have meaningful appellate review, and we go up to 2000. And in 2000, Dean DePiro of the House of Representatives comes in with a change to 295308 and says, you know what, we don't have anything in here right now about those consecutive sentence findings. And so they said, well, we got to get that in. So we put consecutive sentences findings in there. We've given you the legislative history, Director Durall, Representative DePiro, we're all saying we want that to be part of the review. And they also said at this point, let's stop with any issue about what the review is going to be. It's going to be clearly and convincingly contrary to law. All well and good, except that State versus Foster comes around in 2006, and all of a sudden some of those presumptions are no longer viable. Why? Because we have a problem with the right to trial by jury under the 6th Amendment. When HB 86 now turns around in 2011, well, first of all, we get to Kalish, okay? Kalish says, here's what we're gonna do post-Foster. Clearly and contrary to law means, according to Kalish, outside of statutory parameters is the language of the plurality. But what does the plurality then do? The plurality turns around, and every member of the Kalish court said something to the same effect. and said, but we're still going to review the entire sentence. We're still going to review everything the trial judge did. And Kalish says, but we'll do that under an abuse of discretion standard. So Kalish ends up with this two-part analysis. Contrary to law to Kalish means outside of statutory parameters. But Kalish doesn't stop there. And that's what the state of Ohio, through the prosecutor, and I mention the prosecutor only because I have to keep distinct the two institutions that represent the state of Ohio so ably in this case. And the prosecutor says, well, Kalish supports us. No, it doesn't, because Kalish turns around and says, hey, abuse of discretion is still part of the mix. Let's move forward. HB 86 in 2011. Now this is post Foster. And HB 86, the General Assembly turns around and again says, it's not abuse of discretion, that's the standard. The standard is contrary to law and with a deference, clearly and convincingly. So when Markham comes around a few years ago, Markham says, you know what? HB 86, the General Assembly said this is the standard. And guess what, too? They did that, and Markham doesn't really talk about this explicitly, but it kind of references Taylor and the fact that HB 86 had come along when it did. But what Markham recognizes is, hey, post Kalish, HB 86 has again spoken. We're the judicial branch. We have to defer to the General Assembly. And so therefore, we've got to get rid of this idea of abuse of discretion. So Markham turns around and says, Kalish said abuse of discretion. General Assembly said, we're not allowed to use that. We're getting rid of that. But then Markham goes on in that paragraph that we cite and says, but that doesn't mean it's unreviewable. It just means that the standard we use is the clearly and convincingly contrary to law. And that's where we get to when we get here today. Now, the state of Ohio through the general says, well, but this means that the first sentencing is nothing more than a dress rehearsal for the second. Well, no, that's not true. Why? Because a deferential standard like clearly and convincingly doesn't mean a do-over any more than a manifest weight analysis or a sufficiency analysis means a do-over of a jury's verdict. It just means that it can be reviewed with a very deferential standard of review.
So what is being reviewed with the deferential standard of review?
What's being reviewed, Your Honor, is that the court looks at the record. It looks at all the factors that are applicable to that sentence, including 29-29-11 and 29-29-12. And if it says, in this case, this record does not support this sentence in light of those.
What does that mean, this record does not support? Does that mean the appellate court doesn't agree with it, thinks it's too harsh, or is there something more specific in your mind?
No, it has to be, it's the deference of clearly and convincingly and the on-bond.
But clearly and convincing to what? I mean, clearly and convincing that this is, that the judge made the right findings? Because that's not what went on here. Clear and convincing that we think this is the right sentence? Clear and convincing what?
It's not clear and convincing that the judge was right. That's not deferential.
Well, just tell me what it is, just so I know. So if
it's clearly the Court of Appeals, having looked at the record in this case, in light of the applicable law set forth in 29-29-11 concerning proportionality, consistency, goals of sentencing, in light of the 29-29-12 factors, clearly and convincingly find that this sentence doesn't. So
we would clearly and convincingly have weighed the factors differently? I'm just trying to understand. If it's not, I understand when the statute says whether the record clearly and convincingly supports the sentencing findings. I understand how that works, but where there's not sentencing findings, where it's not required to sentencing findings, I'm trying to understand what kind of rule we would possibly write here for lower courts.
It would be a rule that says that in this case, a reasonable jurist could not have found, could not have arrived at this sentence in light of the applicable law.
So it's no reasonable judge would have sentenced this person to this sentence. Is that? And how does that relate to clear and convincingly?
Well, no reasonable. Perhaps I've spoken a little bit more. It's similar to a sufficient. It's similar to a convincingly in other settings, or it's it's a,
well, usually when you have clear and convincingly, you have a certain quantum of evidence that has to be met, and so you weigh that. So, but here we're talking about there's no findings required. So we're talking about balancing. So I'm trying to understand how you would apply that standard.
If a court of appeals looks at the entirety of the record, the sentencing memos, the facts at trial, if there were a trial, everything else, and says, based on these factors, a reasonable judge would not have arrived at this sentence.
So it's really not clear and convincing. It's a reasonable judge standard. Is that?
Clear and convincingly, if you will, is the quantum of proof. We have a firm belief. That's the words I was looking for. Firm belief that based on this record, a trial judge should not arrive at this sentence, and therefore, or the other problem would be in a situation where we have a firm belief, that clear and convincing standard, that a trial judge did not follow or consider the appropriate factors, or sufficiently consider the appropriate factors. Sometimes that's going to happen by virtue of the record and nothing more. Sometimes that's going to be happening by what the judge has said or didn't say in a particular situation.
Let me follow up on Justice DeWine's questions.
Sure.
By observing something that I did not see in the record of the sentencing case. Judges under 292911 are required to impose sentence for similarly situated offenders. There was no presentation in the record that I saw of any evidence of people, sentences imposed on people who were similarly situated to the defendants in this case. Do you know why that is? Do you know why that is? Is that something that should be relevant in every sentencing hearing?
Well, it should be relevant in every sentencing hearing. And of course, the court's recent pronouncements on trying to establish some kind of database statewide with respect to sentences is going to make that an easier matter to try to address. But no, there was no consideration of that. And when
was there any evidence presented that these people needed to be sentenced towards the higher end of the scale in order to protect the public? Or was it just in the trial court judge's mind, the injuries were so heinous? There was a lot of talk about the photograph and the emotions that the photograph drummed up during the course of the trial. But was there any articulation of why this sentence was necessary in order to protect the public, especially when 292911 imposes on trial court judges a duty to use the least amount of our limited resources?
No, there was none. The trial judge really zeroed in on what the trial judge felt were the offensive aspects of the trial, of the offense conduct. And one of the things that the Court of Appeals recognized in its opinion was, they said, look, this is not a situation that's that's going to recur. All right. This is not a situation where incarceration is needed to protect these folks from the public. This is a situation where they came to the court with pristine records, and not just a matter of not having done wrong, but also a matter of, having done a lot of things right in their lives. And so with all of that, a sentence that comes in without a state's recommendation, even to that effect, of 1 year short of the minimum, the irony is that if my client had had a record as long as my arm, the worst he could have done, or she could have done, would have been 1 more year. And so when the Court of Appeals looked at the totality of the circumstances, it found itself saying that this judge did not consider these factors sufficiently. Now, sometimes that's going to happen.
So let me move on a little bit.
Please.
Giving you everything on your argument, if you're right, why didn't the legislature include 2929.11 and .12 under 2953.08 G2A?
Because otherwise contrary to law is broad enough to have already included it. And so what we see in 2953.08 G is that in those situations where a trial judge has to make specific findings, they were the findings that send low-level offenders to prison, the findings for consecutive sentences, the findings for community control sanctions for high-level offenders. In those situations, 5308 G, focuses in and says, in those situations, we want a we want support in the record for each of those findings. In situations where you're dealing with the totality of the circumstances like we have here, you don't have that type of specific mandate, but you still have otherwise contrary to law. It's never gone away. It's still there. And so really, when we get down to plain meaning, what the state of Ohio has to do is say to you, well, ignore otherwise contrary to law. Or say, well, 2929.11, that's not a law. 2929.12, that's not a law. Or do as the general said and says, well, that's a law, but it's a squishy law. And because it's a squishy law, we don't have to follow it, or we don't, it can't become part, not that we don't have to follow it. I don't mean to misstate the general's position, but that it can't be reviewed on appeal. Well, why? Courts of appeals have reviewed things like mens rea, recklessness, looking into the mind of the criminal defendant to determine intent. Courts of appeals have done that for generations. And so there's nothing new about the idea that you look at the record. And what have courts of appeals done in those situations? They defer to the trial court. But at some point, when they have a firm belief that the trial court got it wrong, they have an ability to step in. And that's what this case is about, is are you going to take away, are you going to neuter the Court of Appeals? Are you going to say to the Court of Appeals, no, you can't touch that anymore? Even though SB 2 was intended for that, even though otherwise contrary to law remains in the statute, if otherwise contrary to law had left the statute, then my answer to Mr. Justice Fisher would have to be different. But it has.
Thank you, Mr. Martin.
Thank you.
Thank you. You've used your time.
Thank you.
Okay. Mr. Miranda.
I think there are 2 quick points. First, with respect to the legislative history, the court only looks at legislative history if it finds the statute is ambiguous. And I think for the reasons the general noted, the state's interpretation gives both subsections meaning. The defense interpretation of the statute does not. But even looking at the legislative history, these arguments are defensive in nature. They are identifying the lack of intent on this particular issue. Appellees have not identified a contemporaneous statement or a bill or a committee report where the General Assembly has said contrary to law means appellate courts can reweigh the sentencing factors. And then secondly, with respect to discretion, I would just point out the difficulty with Appellee's interpretation from a practical standpoint. If you look at 2929.11, there are 3 purposes of felony sentencing: protecting the public, punishing the offender, and rehabilitation of the offender using minimum sanctions. And in this case, the 8th District determined that there could be no greater punishment to the Joneses than the death of their child. And you contrast that with the trial court's statement at sentencing, that this was one of the worst examples of the worst photograph of a child's injuries it had ever seen. That just simply is the appellate court substituting its judgment. And in answering questions from the court, appellees have no specific articulation of the limiting principle here that preserves trial court discretion. The phrase reasonable jurist is merely a reformulation of the abuse of discretion standard that this court rejected in Markham. So because the discretion is statutorily placed with the trial court, because the text is plain, the state of Ohio is asking this court to reverse the decision of the 8th District and to hold that 2953.08 does not empower reviewing courts to reweigh those sentencing factors.
Counsel, what in your mind would be an example of something that would be contrary to law that would be reviewable? What would it be? Simply if a trial court judge gave 10 years on a low-level felony of the 5th degree, because that would be contrary to law? Is that the only example of something that would be reviewable?
That's one, certainly something outside the range. If the court didn't consider the factors, if the court considered impermissibly race or sex or gender, that would be, as well as potentially other constitutional violations. Thank you.
Thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you'll be notified of our decision. Thank you, Judge Blunt. Okay. Our second case this morning is 2019-1232, Richard Binder et al. Versus Cuyahoga County. Sitting in for Justice Stewart on this matter is Judge Candace Krause from the 1st District Court of Appeals. Welcome, Judge. For the appellant, we have Mr. Lambert.
Madam Chief Justice, and may it please the court. My name is David Lambert. I'm an assistant prosecuting attorney for Cuyahoga County. Appearing on behalf of the county, I would like to reserve 3 minutes for rebuttal. This case, this appeal presents an important issue of Ohio civil service law and an important issue of the jurisdiction of the Common Pleas Court to enforce that law. And the question is this: may a member of the classified civil service of the state of Ohio who alleges that he is improperly reduced in pay bypass or fail to utilize his statutory rights to appeal to the Civil Service Commission of the county, here that's called the PRC, to forego that appeal and instead go into Common Pleas Court and file a lawsuit? In this case, the lawsuit was a 2-count lawsuit, the first one being a damage claim and the second one being a declaratory judgment claim. That is precisely the lawsuits that were filed in this case in Common Pleas Court in 2015 and 16 concerning alleged pay reductions that happened in 2012 when Cuyahoga County converted from a statutory county to a charter county. And what happened at that time was the county had different offices. Some of them were under a regime where they would have a 35-hour work week with no paid lunch. Others had a 40-hour work week with a paid lunch. In order to unify the system, the county went through this change. The change was non-controversial. We contend, as we've explained in our brief, there was no reduction in anyone's pay, no reduction in their daily pay, their weekly pay, their biweekly pay, their annual pay. The only reduction was in the nominal hourly rate.
So doesn't your colleagues on the other side say that that does make a difference, that there was a reduction because if your hourly rate is reduced for things like comp time, for example, that's based on an hourly rate. So I guess the first question is, isn't there some reduction? And the second question is, does that matter to us right now?
I don't think you're correct, Your Honor. This is a merits issue. I don't know that it really goes to the question of the jurisdiction of the Common Pleas Court. However, I would like to say that the alleged reduction that plaintiffs have claimed all along, they've progressively pared that back since they have been forced to concede. But there really is no reduction in anyone's compensation. And the other thing is, every person who had accumulated comp time, sick time, vacation time, they were all adjusted upwards by means of an outside consulting firm. And so we don't believe that there is any loss to any county employee. Going forward, if you have to spin out a scenario where someone would take comp time and try to be cashed out of it. But there's other scenarios too. If you're working 8 hours accumulating comp time, you're now getting paid for your lunch hour. So you accumulate 8 hours instead of 7 hours.
But let's say there are employees out there who still think that there has been a reduction. If we say that the Common Pleas Court doesn't have jurisdiction, do they have any recourse now?
Yes, Your Honor. They have recourse to the PRC, the County Civil Service Commission. That jurisdiction is contained in 12434 of the Ohio Revised Code, which was adopted by the county as part of its code, and which is, the county also has a provision in its charter that says that the PRC has the same jurisdiction as the Personnel Review Commission. So in fact,
would they have that right of appeal now? Or does it, as I read it, it has a 90-day appeal period. Has that passed?
That has passed. That passed back in 2012 when this occurred. So yes, they at this point they do not have an appeal right. They forewent that appeal right for whatever reason. We believe they didn't appeal because nobody felt adversely affected, and it was only several years later when someone had concocted this scenario where there might be some type of scenario where you would in the future have reduced benefits of comp time, which is not a vested right, as we've argued in our briefs. But the issue here about the jurisdiction of the Common Pleas Court was raised by us immediately when we were defending the case in Common Pleas Court. We raised the subject matter jurisdiction of the Common Pleas Court, and we raised it in our motion for judgment on the pleadings, and we raised it in the motion practice where the court certified a class. And the claim we made was that the proceedings at issue, the matter sought to be adjudicated by the Common Pleas Court, was a matter that was committed to the special statutory proceeding jurisdiction of the Civil Service Commission of Ohio, the PRC. Now, that is a jurisdictional defense. We've argued it's jurisdictional from the very beginning, but the trial court and the Court of Appeals are relying on zoning cases, which we believe are completely inapposite to this case, and analyze the law saying that that's merely an affirmative defense that does not defeat subject matter jurisdiction. We believe that's wrong, and we're asking this court to reverse that and to clarify the law in Ohio to say that when a matter is committed to the jurisdiction of an administrative body by means of a comprehensive statutory scheme, that the jurisdiction of that administrative body is exclusive, at least in the initial hearing. Obviously, an administrative body is subjected to judicial review by the Common Pleas Court and the Court of Appeals, and this court just on a discretionary basis pursuant to 250106 and 11912. So what we object to is that the bypassing of the administrative body by means of a lawsuit in common pleas. Now that, you know,
Can
the lawsuit,
can the PRC award back pay?
yes,
Do they have that ability?
Yes. The State Personnel Board Review, every civil service commission in the state, when you disaffirm a reduction, when you disaffirm a suspension or a termination, the disaffirmance by operation of law reinstates the employee back to the day he was fired or disciplined or reduced, and he is reinstated with back pay, benefits. He accrues vacation time for the time he's off. I mean, imagine.
Counsel, and this, one of the arguments posed is that there's so many employees that were affected here. I think it was it 400? Am I remembering the correct number? Anyway, the observation would be that this would take so much time if they had to go through the tedious process of the administrative first and then find themselves in the court, that people may very well, you know, be retired by the time this gets resolved under the county's structure.
Well, Your Honor, I don't believe that's practically true because the PRC in the past has shown itself able to increase its workforce to meet the needs of its caseload. There's 400 cases here. There's a case that we cited out of Youngstown, State Ex Rel. Vukovic versus Youngstown. In that case, it was 900 people who appealed. But the whether or not there would be some delay, I mean, it's a little ironic since it took the plaintiffs here 5 years to file this lawsuit and it's been pending for 5 years. So the idea that they're getting some type of speedy relief in the common pleas court is somewhat ironic. But the law in this case and in this state, the case of Nemesi versus Mount Sinai and Teamsters Local versus 436 does not equate futility with time consuming and bothersome, nor does it equate futility. And that's the argument that the plaintiffs are making here. They're saying it's futile to go to the Personnel Review Commission. And the other thing that futility does not equal, which is the probability of receiving a remedy. The question is, does the body have the power in the abstract, the potential power to give you the relief you are asking for, not whether you're going to get it. That would turn futility on the basis of the strength of your case. So the existence of a large body of employees, and I don't think it's unreasonable to assume that the Personnel Review Commission, if they were to hear cases that have similar issues, that they would enact some type of process whereby they would streamline the hearing. They're not going to hear the same legal issue over and over again.
Well, Counsel, I would imagine that after you've maybe ruled on 5 or 10 of these, there would be an understanding, depending on what the ruling was. If it was favorable to the employees, the county would just proceed with whatever was necessary. Absolutely. As opposed to continue, 380 more cases.
Absolutely, Your Honor. I agree 100%. So as we have urged below, and we are urging today, the doctrine that we are invoking, which deprives the Common Pleas Court of the authority to adjudicate this matter, is the doctrine that we're calling the Special Statutory Proceeding Doctrine. And this court about a month ago issued a decision that we believe is dispositive of this case. That case is Pavanka. And in the case of Pavanka, I'm sure you recall, there was a class action lawsuit brought into Common Pleas Court of Cuyahoga County seeking to recover proper money that had been improperly collected by the State Bureau of Workers' Compensation. There was a statute enacted by the General Assembly that provided an administrative method of doing it. And this court said that when the General Assembly vests exclusive jurisdiction in an agency, That is when the agency, when it enacts a comprehensive statutory review by that, or scheme of review by that agency. We believe 12434 is such a comprehensive review. And this court has also held in a case called Albright that when there is such a comprehensive statutory review, it is always inappropriate for common pleas court to issue declaratory judgments which attempt to resolve those matters which are committed to the exclusive jurisdiction of an administrative agency. And I would
as I recall with Pavanka, there was a mass order that went out that notified anybody who had made a claim of this new administrative proceeding. In this case, were there individual orders that were issued so that an individual working for the county would know that they had the ability to go to SPBR or to PRC, excuse me?
No, Your Honor, there were not. And that's where we invoke the no order reduction rule. And that's exactly why the no order reduction rule exists. We don't believe we reduced anyone. It's inconsistent with common sense and our belief of facts of this case that we would send somebody out an order saying, we're reducing your pay when we don't believe we've reduced your pay. Somebody that was on Friday was making $80 an hour, a day. On Monday is still making $80 an hour. He's just having a timesheet that reflects 8 hours of work as opposed to 7. So we did not send that out.
I certainly understand that, but I guess that kind of creates a circular, it's kind of circular reasoning, is it not? We're not reducing your pay, so we're not issuing an order. But by not issuing an order, that doesn't kick off. It doesn't begin the process then for asking the very question, does this reduce my pay? That's kind of the trouble that I'm having.
Well, they would see the change in their pay stub. And again, we have a body of law about a no order reduction. Instead of having 30 days to appeal, you have 90 days to appeal. And the no order reduction rule is a rule that is designed to protect employees. If you show up at work one day and your boss says, you're no longer the supervisor, you're an ordinary employee, you say, well, give me an order. He says, no, you can still appeal that even without the existence of the order. And so in this case, when people realized that they were being paid based upon a different hourly calculation, that was what triggered their ability to appeal. And they had 90 days to do it, and no one did that. And that is why they've given up their
counsel. How would they know the process? How would they know the process for the appeal? Is there a handbook that lays this out? Is there how would that be known to the 400 plus employees?
Well, I would suggest, Your Honor, it's common knowledge, but I can't quote you chapter and verse whether the employee handbook talks about employees' right to appeal adverse actions to the SPB.
Well, the form of government that Cuyahoga County uses now, the charter form of government, was relatively new, correct?
Yes, Your Honor.
Okay.
It existed in Summit County for 20 or 30 years.
I'm very familiar with that, having been the prosecuting attorney in Summit County. But let me just, you've got this new form of government, you've got this new review board. How does the employee supposed to know that they, number one, have recourse, and number two, what that path is for the recourse? Well,
I guess I would argue that they don't have to be told to be bound by the 90-day no order reduction rule. At the same time, I will say this, not to go off into a tangent. At the same time, the county came upon a situation where we had a classification system that was completely inconsistent. We had people with no job titles, no job descriptions. Certain people doing the same job were being paid differently. And the county went through a massive kind of reorganization of the civil service. This was part of that process. And it was well known to people. And many people had their pay reduced and filed, and again, some of them filed cases in SPB or in the PRC, and other ones are part of the other two class actions filed by counsel in this case. So I don't think it was a secret, is what I'm saying.
Okay. All right. Thank you. Thank you, Counselor. You've used all of your time. Mr. Cohen? You'll have to unmute yourself, sir.
There we go. Madam Chief Justice, may it please the court. The 8th District properly certified the class in this case because all requirements of Rule 23 had been met. And the trial court had subject matter jurisdiction in this case because the pay cut in question arose from passage of an ordinance, which doesn't fall within the it's not the sort of action that was subject to this exclusive administrative review that Mr. Lambert was talking about. There is no dispute from us that the enactment of a comprehensive statutory scheme can create exclusive administrative jurisdiction over disputes within its purview. And there's no dispute that the General Assembly created such a comprehensive scheme with respect to the civil service. The dispute lies in the scope of that statute. The PRC reviews final decisions of appointing authorities. The extension of the work week came about, as I said, through passage of an ordinance, not through any action or final decision of an appointing authority, and that is not reviewable pursuant to the terms of the statute. So this is not a radical departure from the case law of governing civil service law. It's not opening the floodgates to new litigation. This merely endorses a longstanding principle of Ohio jurisprudence, and that is that statutes are enforced as they're written. And
what about the charter, though? I mean, you're talking about the statute, but what about the section of the charter, 9.02?
This charter said,
which gives responsibility for the resolution of all personnel matters.
It does.
Do we ignore that?
No, you don't ignore that but that language in section 902 is qualified, but what comes right after that language, which defines the appellate jurisdiction of the PRC, which says that it is coexistent or coextensive with what the appellate jurisdiction is of the State Personnel Board of Review, which limits the jurisdiction to review of final decisions of the of appointing authorities and the Board of Administration. And you also have to look at that in conjunction with the administrative rules of the PRC itself at the time that this took place. The PRC itself and its administrative rules only had accepted appellate review over final decisions or final judgments of appointing authorities. So that doesn't exist in isolation. This was talking about the issue here is their appellate jurisdiction, and those provisions.
So if a city council makes personnel decisions, the employee loses all their rights guaranteed to them by Revised Code 124?
Pardon, Your Honor, I missed that.
If a city council makes personnel decisions, or if a suppose a city manager says, you know, I want to reduce pay for these people, let's put in an ordinance. That's not reviewable under 124. The employee loses all their rights under that section.
Your Honor, there can be intermediate steps in these sorts of things.
Well, you just said that if a city council, if it's done through a resolution, then 124 doesn't apply. I mean, that would seem that would seem to give municipal governments a lot of leeway to take steps that affect their employees without their employees having any appeal rights.
Your Honor, first of all, this is not a situation that has come up to my knowledge, except in the Vukovic case. That's the only other case that I found where an ordinance would be used. And secondly, it doesn't seem to be, why would a city manager go through having an ordinance enacted to take a personnel decision?
Well, because for one thing, you just told me that if you do that, then the employee has no rights under Section 124.
But under our version of or conception of the law, they would have appellate rights in the court under those circumstances, because 124.34 doesn't absolutely preclude any sort of review under those circumstances. The employee would not be without.
What is the cause of
right.
action that someone would have?
Pardon?
What is the cause of action that an employee would have?
The cause of action would be for violation of 124.34.
The section that doesn't apply.
The appellate provision doesn't apply. The appellate remedy doesn't apply, but the substantive right does apply. The substantive right that it creates does apply.
If
In
we
fact,
are gonna
counsel, 124.34 says that, quote, no officer or employee shall be reduced in pay, close quote. And then there's some exceptions and reasons, right?
Yes, that's what it says.
So why wouldn't this go under 124.34? You're arguing your clients had a decrease in pay.
It does go under 124.34, Your Honor, but what I would suggest is that the appellate procedure that's created as part of that provision does not cover this situation. It creates a substantive right, but the two parts are severable. They're not unified. That it doesn't, that an employee doesn't lose his right to protection from a unjustifiable reduction in pay simply because the appellate right that's created in the statute doesn't apply in his particular case.
So what is it that we should look to in 124 then that creates a private right of action? Is there something there that says that it creates a private right of action?
There's nothing in the statute that says it's a private right of action, Your Honor. It has to do is, the case law is not helpful in addressing that issue. I can say that the case law that is cited to suggest that it doesn't exist isn't applicable, in my view. Anderson, I don't think precludes it. And I think that the decision in Bowling Green keeps open the possibility that the courts could consider something like this for in a situation where an appellate review isn't available.
Thank you.
Your Honor, you raised this question in talking to Mr. Lambert about the issue of notice. And there's something inherently contradictory about the county's position. Excuse me? About the county's position here. On the one hand, they're claiming that there was no reduction in pay, and yet they don't give any notice. But now they're saying that the employees were obliged to appeal to the PRC. That doesn't jive. I mean, how can employees be obligated to pursue an administrative remedy if no pay cut took place? The two things are inconsistent. And there's another sort of disconnect here, and that is the delay that the county had in asserting this supposed exclusive jurisdiction of the PRC. We pointed this out in our brief that there was a lapse between the time that these cases were filed and when the county first asserted that there was exclusive administrative jurisdiction. And we're not claiming that there was necessarily a waiver, but what we're saying is that shows a recognition that that this was not a typical sort of case that falls within the scope of the PRC's review. This is something different. And
have we not said repeatedly that you can bring up subject matter jurisdiction at any time?
You can bring up subject matter jurisdiction at any time, Your Honor. But what I'm suggesting is not that they waived it, but that their delay was recognition of the fact, their initial recognition of the fact that this wasn't a typical PRC matter, that, something changed. They talk about how our 5-year delay, somebody got a notion a notion that this was something different. I'm saying that they got a notion that this was something different after time. Your Honor, there has been an argument that exhaustion of administrative remedies should be an element of standing. That was one of the proposals in one of the propositions of law. And I would suggest that that is not a necessary change to the law. Exhaustion is an affirmative defense generally, and that there are various evidentiary factors that can determine its applicability. Did the plaintiff do what was required to exhaust? Did the defendants waive the defense? Did the administrative remedy, was it too onerous in this situation? And I don't think there's any need to put the plaintiff through the burden of proving that as a precondition to establishing his standing to sue. If the defendants want to raise this as an issue in class certification states, they can do it through typicality and argue that that defense creates an onerous burden or too onerous a burden that's going to distract the plaintiff from pursuing its case and do it that way. Your Honor, finally, let me just touch a minute on the merits that Mr. Lambert alluded to, that, that there was no pay cut here. The statute itself says that there would be a reduction in the hourly rate. In Binder 1, the first time the Court of Appeals discussed or addressed this case in Binder, it held that employees have a legally protectable right in their hourly rates. And not beyond that, the appellee's claims are based on the premise that when an employer gives an employee a paid lunch, they actually have to pay them for it. And the fact is that when other departments at the county made this transition from having an unpaid lunch to a paid lunch, they got pay raises, as is reflective of the fact that their hourly rates were going down and that they should get some recognition of that. And the plaintiffs in this case are just asking for that similar sort of treatment. If your honors have no further questions, I would conclude and say, ask the court to affirm the judgment of the 8th District. Thank you.
Thank you. Mr. Lambert, you've used all your time. You may take a minute. You'll have to unmute yourself.
Thank you, Your Honor. The idea that this is some magical legislative way of reducing people's pay. When the legislature passes a law, it's implemented by the appointing authority. Only the appointing authority can cut your pay. And if when that appointing authority cuts your pay, that's an adverse employment action. That's a final decision that you can appeal. Mr. Cohen's argument flies directly in the face of Vukovic, where virtually the exact same thing happened, and this court held that the Civil Service Commission there had jurisdiction. And I believe Justice DeWine's question is very pertinent. The idea that, oh, this is a different kettle of fish because it originated in councilmanic action is just wrong. And back to the issue of notice. If you walk into your pay at your office and your boss says, oh, by the way, you're making half what you made on Friday, and I'm not giving you an order, that is a adverse action by him, and you can appeal that. And that's why the no order reduction appeal exists. And I would just say that the precedent set in this case is going to make appeals to the SPBR and the local civil service commissions optional, and that will open the floodgates of lawyers and lawyers who want to file class action lawsuits and bringing those cases in the common pleas courts, where the courts are already overcrowded and they don't have the expertise that these specialized administrative bodies do.
Well, counsel, except that the appeal does go to the common pleas court, correct?
Yes, Your
Once
Honor.
it exhausts your administrative, it does go to the common pleas court. So they are equipped to handle these sort of, subject matter cases. But let me ask you, Mr. Cohen suggested that 124 can be parsed and that an employee can have a right established under 124 and can jettison then the process to enforce that right. At least if I understood his argument. And instead of going to the PRC, they can go with the established right under 124 to the common pleas court directly. Would you comment on that?
Well, I think that, Your Honor, that flies directly in the face of a large body of law in this case that says when a statute confers the right, it also will confer often the means by which you enforce that right. And that's clearly what happened in this case. You can't take a right from a statute that says, here's how you enforce it and say, I'll segregate out the right and I'll enforce it the way I want to by filing a civil lawsuit. That's just inconsistent with Ohio law. And there's another body of law that says the existence of a statutory right by itself or a constitutional right does not create a cause of action. And so we believe that Anderson versus Minter is the case that stands for that proposition. So we believe that there is no implied cause of action in common pleas based on 124.34.
Thank you. Thank you, gentlemen. We will take the matter under advisement. You'll be notified of our decision. Marshall, will you call a recess, please?
The court will now take a brief recess.
Good.
Is Justice Donnelly within earshot? Good morning, ladies and gentlemen. We're here on our third case this morning, 2019-838, Columbia Gas Transmission LLC versus the Ohio Valley Coal Company Corporation System et al. For the appellant, Mr. Fleischner.
Yes. Good morning, Your Honor. And before I begin, I'd like to reserve 3 minutes for rebuttal. Chief Justice O'Connor, may it please the court. This is a property rights dispute between a coal mining company, Ohio Valley, and a pipeline company, Columbia Gas. Columbia had to protect its pipelines from subsidence in advance of Ohio Valley's undermining and wants Ohio Valley to pay for it. For decades, coal companies and pipeline companies have used a comparative property rights analysis to decide who pays to protect the pipelines. In this case, Ohio Valley's common law property rights are first in time and superior to Columbia Gas's later acquired rights of way. Ohio Valley owns the right to mine, the right to subside the surface, and the right to do both without any liability. At common law, the party with the inferior property rights generally pays to protect the pipelines. That's the status quo. The 10th District held that Ohio SMACRA changed the status quo, and all 3 propositions of law accepted by this court challenged that holding. Prior to this case, no Ohio case held that SMACRA invalidated common law property rights for the benefit of commercial structures. Our brief examines the relevant precedent, East Ohio Gas, Capstone, DeCouliac, all decided after Ohio SMACRA took effect. And in each one of those cases, the court relied on common law property rights, not Ohio SMACRA, to decide whether and to what extent the coal mine operators were entitled to their coal at the expense of the surface owners. Now, Columbia Gas in their briefs say these cases are irrelevant because the outcomes would have been different had those cases been decided by or considered Ohio SMACRA. And that's not true. And the text of Ohio SMACRA's scheme proves it. The Ohio SMACRA statute is found at Revised Code 151302. And that says that ODNR's Division of Mineral Resources Management shall adopt rules to meet the requirements of federal SMACRA.
Counsel, I'd like to address that point. This question of meat is getting a lot of attention in the briefing. Does that not just mean that they have to fulfill the obligations under the federal law? That's just part of the implementing legislation?
Well, I think I would agree with you because federal SMACRA expressly preserves common law property rights as to commercial structures. Federal SMACRA, which is codified at 30 CFR 817-121 C2 and C3, tells mine permittees, look, if you damage homes or non-commercial structures, you need to either repair it or compensate those owners. However, for non-commercial structures, for commercial structures, they are entitled to the repair or compensation benefit, but only to the extent required under applicable provisions of state law. That means common law. So federal SMACRA says if you're a commercial structure owner and you have inferior property rights, you are not entitled to the repair or compensation benefit.
But what if we interpret provisions of state law to include the Ohio Administrative Code, where you have a rule that doesn't just say commercial structure, it says any structure.
And my response to that would be in derogation of the common law. And under the Ohio Supreme Court case in Fulton, one of the principles of statutory construction, which also applies to regulatory construction, is that those laws are going to be read consistent with the Ohio common law, unless it is clear from the statute or the body that they are intending to change the common law. I would also submit that an administrative agency can't invalidate common law rights unless it has authority from the General Assembly to do so. That comes from the McAfee case, another Ohio Supreme Court case cited in the briefs. Here you have the General Assembly telling ODNR, you shall adopt and administer rules to meet federal SMACRA, and federal SMACRA preserves common law property interests as to commercial structures.
But that just gets back to my first point, that you're using the word meet to say meet but not exceed. And couldn't have the General Assembly could have said that. The General Assembly could have said, you have to adopt rules to implement the federal law, but you can't make them more stringent than the federal law. The General Assembly didn't do that here.
The General Assembly wrote a very simple and had a clear directive to ODNR that said you pass laws to meet federal SMACRA. And if federal SMACRA says we're protecting common law rights, then ODNR can't then turn around and eliminate common law rights. It doesn't have the authority to do that. Its authority is drawn from the statute.
So the question, let's say, if the Ohio Administrative Code, if the rule had used the same language as the federal law, you would say that it could abrogate common law rights?
That would be consistent with federal SMACRA. Federal SMACRA did abrogate common law rights as to homes, surface lands, and non-commercial structures, but it preserved the common law rights as to commercial structures. And so, yes, what you said is correct. I would agree with that. It also bears mentioning that ODNR testified at trial. Scott Steitler testified at trial and said that the subsidence control rule did not apply to pipelines. That's the first proposition of law. Now, if this court accepts the proposition that the Ohio SMACRA scheme changed the status quo, that a commercial structure owner can recover subsidence damages despite having inferior property rights at common law, then the Ohio SMACRA scheme must dictate the subsidence damages that can be recovered. Now, while the Ohio SMACRA statute doesn't address subsidence damages, the regulation does. 1501.1312.03F says you get compensation in the full amount of the diminution in value resulting from subsidence. That means you get the difference in the value of the damaged pipeline post-subsidence and pre-subsidence. That's all you get, post-subsidence damages only. Columbia couldn't prove these damages at trial. The 10th District considered that absurd. They thought that the pipeline owner should be able to recover its preventative costs. And because the 10th District didn't have any regulatory authority to order Ohio Valley to pay for preventative measures, the 10th District applied the foreseeability rule in tort. In other words, the logic was that since it was foreseeable that Columbia would incur costs to protect against what they characterize as the inevitable damage to the pipeline, that Columbia should be able to recover those costs as damages. But that's not diminution in value. That's not the remedy expressed in the regulation. That was error, and that's our second proposition of law. The 10th District substituted a measure of damages it preferred based in tort for the remedy in the actual Ohio SMACRA regulation. Now, not only did the 10th, sorry, go ahead.
I'll interrupt you a minute, but as I understand it, Ohio Valley is saying, too, we did these preventative measures because Columbia didn't fulfill its obligation when it comes to subsidence of the land to be sure their pipeline was protected. So they went ahead and did so, one, to avoid substantial damage, not only to their property, but, I guess potential extreme or catastrophic damages to any others. So why aren't those costs recoverable? Are you saying that Columbia Gas should not have done anything, and then when or if, and in their opinion, when subsidence causes damage to their pipeline, then you'll say, well, you should have done something to protect it?
Absolutely not. And that gets to really the third proposition of law. The assumptions that Columbia Gas makes, and the 10th District makes the same assumption, is that we would have just continued to undermine an unprotected pipeline and created all this damage and all this chaos and harmed Ohio citizens everywhere. And that's not the case. Not only is it not supported anywhere in the record, the 10th District doesn't cite to any of that in the record, and Columbia Gas's counsel won't be able to cite you to anywhere in the record where we were going to do that.
When you say doesn't cite to that in the record, are you saying there's no proof, there's no evidence that Ohio Valley would have continued the type of mining, the longwall mining that it did or that it does?
Correct. If Columbia Gas had not protected their pipeline in advance of our mining, we would have had to stop. That evidence is in the record. The permits that are part of the record make very clear, expressly tell Ohio Valley, if Columbia Gas does not protect their pipelines, you are to stop mining. We are issuing a cease and desist order. And so that was really the big flaw with the 10th District's opinion. Two big flaws is they're using a legal act as a basis for damages. Mining is lawful. Subsidence is lawful. This is all expressly authorized in both federal SMACRA and Ohio SMACRA. The trial court even made a finding of fact that subsidence and longwall mining was lawful. So a lawful act cannot be a tort or a basis for damages. That's an Ohio Supreme Court case, the Richley decision. It's cited in the briefs.
Do you think Ohio Valley had any responsibility to protect, to do something other than not mine? But if there was a business decision or some decision made that you needed to continue to do mining in that 2-mile area of the pipeline, is there any other obligation or responsibility by Ohio Valley other than not doing longwall mining?
Yes, actually, they have a regulatory responsibility to keep Columbia informed of their mining progress and where they're going to be and when they're going to be in the longwall panels so that Columbia Gas can take the measures, the mitigation measures necessary to protect their pipeline.
How is that different than what's happened here?
Because what Columbia Gas is saying is we have to pay for all of the measures that they took. We will let them know in advance of where we're going to be so that Columbia, can take the measures necessary to implement the plan and to make the payments to make sure that their pipeline is protected.
So you're saying at all times it was Columbia Gas's responsibility to protect their pipeline, whether now in mitigation or later when you say you're going to be in that area, but at no time is there responsibility of Ohio Valley.
Our Ohio Valley's responsibility under the regulation is to communicate with Columbia Gas and make sure they know where we're going to be and when we're going to be on the panel so that they can protect their pipeline. That's our responsibility. And last, very quickly, the other flaw in the decision is that damages can't accrue before a tort or legal injury has occurred. The 10th District is awarding preventative damages, saying, Columbia, you can recover costs to prevent a harm that may not even occur without having to first show that an unlawful act occurred in and of itself. And I can see with the timer, I'd like to reserve the rest of my time for rebuttal unless there's other questions.
Thank you. Mr. Muska.
May it please the court, Joseph Muska on behalf of Appellee Columbia Gas Transmission. the 10th District Court of Appeals decided this case correctly. To end up with a different outcome would be an unreasonable and inequitable result that is contrary to well-settled law and Ohio SMCRA. This court should therefore affirm the 10th District Court of Appeals decision and remand this case to the trial court for a final determination of Columbia's damages here. Because Ohio Valley Coal rejected any legal or financial obligation under Ohio SMCRA, Columbia, as the good corporate citizen here, was forced to incur necessary costs to protect its natural gas pipeline from the imminent, inevitable, and impending damage that was guaranteed to occur as a result of OVC's environmentally damaging longwall mining coal operations.
Mr. Musker, you said that was inevitable to occur. What if they never did mining in the area of the pipeline?
Well, then I respectfully would say that this would not have been an issue then. If there was no longwall mining that would occur, then we would not end up here today.
Well, but I guess as opposing counsel said, Ohio Valley had not done longwall mining in that area, and their obligation was to let you know if and when they were going to do so. Is that incorrect?
No, so at the genesis of this, before the longwall mining occurred, Ohio Valley Coal submitted a subsidence control plan to Columbia Gas, and in that control plan, which it's Ohio Valley Coal's legal obligation, basically stated that it is Columbia Gas's responsibility to protect its pipeline. They shifted their legal obligation under the subsidence control plan, and which, I mean, it spells out, it's in the briefing and it's well developed in the record here, that they had a responsibility to prevent and minimize damages as a result of longwall mining.
And are you saying that they had that responsibility based on what you said in your plan, or is that responsibility on them by statute or administrative code?
The responsibility is under the Ohio SMCRA statute, and specifically, if you look at Ohio Administrative Code 1501.13.11.02c, states that Ohio SMCRA mandates that all coal mining operations shall be conducted in a manner which minimizes damages, destruction, or disruption of services provided by gas pipelines which pass over, under, or through the permit area.
And why can't Columbia Gas rely upon that for support that you should pay for, or at least help pay for, their mitigating damages to their pipeline?
Throughout Ohio SMCRA, there's a lot of other obligations that Ohio Valley Coal has to meet to even get the permit. And so with respect to pipelines, there's all sorts of obligations that they have to minimize and prevent other damage to other properties. And they relied upon, respectfully, a mistaken interpretation of Ohio law on that issue, that Columbia Gas's pipeline was not a protected structure or facility, and proceeded to force Columbia to pay these mitigation costs. Because Ohio Valley Coal is proceeding in such a way that they are making these mining operations, these are for-profit mining operations, and they're trying to shift the cost onto another entity to bear the cost of those mining operations.
Council, what about the permit that Department of Natural Resources has issued? Did it anticipate this issue with the pipeline?
It did. There was a at first, on the very face of the permit, there's a statement that the permit is issued and it's still subject to all local, state, and federal law and Ohio SMCRA. But it did also address the issue that if longwall mining did occur within a certain degree of the pipeline, then the mining operations would have to cease, and this case would have ended up in a very different procedural posture than the cases currently before the court. It just would have ended up in a different way.
But would you agree that the permit says that if Columbia Gas does not shore up the pipeline, then the mining has to stop? And so doesn't the permit then really shift the burden to Columbia Gas in order to, that you have to do that?
I would agree that permit states that the pipeline had to be protected before mining could occur, but in other parts of Ohio SMCRA, the obligation is on the permittee, Ohio Valley Coal, to make sure that the pipeline is protected. It shouldn't be on Columbia to bear those costs of protecting its pipeline.
Counsel, as long as you're relying on administrative code for your claim, doesn't 1501 13-12-03F really talk about past damages, not preventative damages?
Yes, that's correct, Your Honor.
So why are you entitled to preventative damages then?
We filed this claim under RC 1513-15H, which is a broader remedial statute that allows for damages for any violation of Ohio SMCRA or the permit. And the narrow administrative code that allows for damages after the fact, that's what the trial court looked at and said that there was no damage from subsidence, but the appellate court got this correct when they looked at it from a broader perspective and looked at this case that there are damages here for a violation of Ohio SMCRA, and these are in the form of preventative damages.
But that's only if we find that the coal company was responsible for the mitigation, correct?
That's correct. If there has to be the liability under Ohio SMCRA that the pipeline is a protected facility or structure for there to be damages.
And do you think you get there through 1513.15H?
I do. I think that's the broader remedial statute, because I think if there's no, on the issue of preventative damages, if there's no recourse here for Columbia, the statute would result in an absurd outcome. There's no incentive here in the policy of the state for Columbia Gas as a pipeline operator to sit back and just let the damages occur, and then they can recover those damages from OVC.
Well, I think that I don't know that there's a debate that if damages occur, well, Columbia has an obligation to secure their pipeline in the face of longwall mining, correct?
Correct.
Okay. And presumably, if they do that correctly, there is no damages.
Correct.
Right?
Correct.
And did that happen here?
There were no damages to the pipeline. These are
because everybody did what they were supposed to do according to both the regs and the permit, correct?
Correct.
And so now you're just saying we did what we were mandated to do, Columbia, and I guess they carefully did longwall mining so that there was no negative repercussions. So there are no damages here.
In the traditional sense of damages after the fact, but this is a very unique case and a very unique set of circumstances, unlikely to repeat itself again here. This isn't these preventative.
This doesn't happen. What's so unique about it? Is it the longwall mining is unique? The fact that there's a gas line close to a coal reserve? What's unique about that?
Well, that is a very unique issue. I think
because if it's that unique, would you repeat that?
I'm sorry, Justice O'Connor, you cut out there for a minute.
Okay, can you repeat what you said? Why is this unique?
This is unique because of Ohio SMCRA issues are not litigated in Ohio. This is a case of first impression. This isn't something that typically comes up throughout the court system here, and I think it's also unique in the sense of the procedural posture of this case. This case could have started in many different ways. It could have started with Columbia Gas seeking a TRO against Ohio Valley Coal. It could have started at at a very different stage. So I think just the facts of the case and the procedural posture make it very unique with respect that the longwall mining occurred and Columbia Gas took these damages, and these damages were presented at trial as evidence, and the trial court elected not to award those damages And the appellate court here looked at the statute as a whole and looked at the remedial provision of Ohio SMCRA and allowed for Columbia Gas to, come up with these damages in the form of the affirmative side of the avoidable consequence.
Where does ODNR get the authority to promulgate this regulation?
That would be, I believe, in the revised code.
And the revised code gives them authority to implement SMCRA.
That's correct.
But how does that language give the bureaucracy the power to create a regulation that takes away property rights that SMCRA does not take away?
Well, first, I think this is an issue here before this court, is that Ohio SMCRA only had to meet federal SMCRA. It could definitely go beyond.
Sure, it could go beyond, but doesn't it have to be authorized by the legislature to go beyond? I mean, the ODNR has no power in and of itself to create law, does it?
No, it does not. And this was
so. How can it take away more property rights than the legislature authorized them to do?
Because the code sections were changed, and it removed a certain section of the code that deleted the reliance on property conveyance or other agreement and shifted to the provision that allowed for the permittee to work out a deal, and if they didn't have a pre-mining agreement.
Well, but let's just look at back up though a second. The statute only gave ODNR the authority to implement regulations to meet the requirements of federal SMCRA, right?
Right.
And so these regulations you're relying on go beyond the requirements of federal SMCRA, right?
That's correct.
So I guess that brings me to my initial question. How does ODNR have that authority to do that?
I believe they have the rulemaking authority inside the revised code.
But don't they have to be, there doesn't have to be an explicit grant of authority? They can't just make up rules to take away property rights generally, can they?
Right, and I believe that's in the part of the rulemaking authority, but I can't say for certain one way or the other.
Does the rulemaking authority, once the rules are created, are they approved by the legislature?
There is a process, and it's that process that's Amendment 38 that's listed in the supplement and cited throughout our merit brief. Amendment 38 was approved. It went through this long process and approved in 1991. And this was, received public comments and everything else. And that was the fundamental change here that kind of caused all of this to come in motion, is that when that amendment number 38 was approved, it changed Ohio law on that issue.
Council, I want to go back to 1513.15H. Quote, any person who is injured, okay? Now, preventative damages prevent injury, correct?
Correct.
So how was the gas company injured?
The injury was wholly financial in nature.
I know, but it was preventative.
Correct.
But that doesn't, you don't know if you would have been injured. That's speculative, isn't it? You don't know if you've been injured if you hadn't done the preventative.
It's not speculative, because throughout the record, there are findings by the trial court that subsidence was going to happen, and it was guaranteed to cause subsidence of the land. When the longwall mining happened, it was guaranteed to cause subsidence. I have it on page 37 of my merit brief, very specific factual findings from the trial court.
But that says who was injured. That's my point. You're relying on the statute, and the statute looks ex post and not in futuro.
That's correct. And it's because if we didn't take these measures to protect the pipeline from the damage that is absolutely certain to occur from longwall mining, we would have been able to have those damages. There has to be some corollary obligation here to allow Columbia Gas to recover those damages. And it comes in the form of preventative damages or the affirmative side of the avoidable consequences doctrine, which as an affirmative defense, a party has an obligation to avoid or mitigate damages. But it is Hornbook law. It's not well defined in the law, but it does allow for certain preventative damages to it.
But that's the common law theory, correct?
That is the common law theory, yes.
So really your damages, preventative damages truly are based on preventative common law basis.
Yes.
And thus, if it was waived, if common law rights were waived, you have no claim.
That's correct.
Thank you. Thank you, Counselor. You've used your time.
Okay, thank you.
Counsel, you've saved yourself 1 minute and 37 seconds.
Thank you, Your Honor. There's no evidence in the record that there was going to be any damage to the Columbia Gas pipeline. That was an assumption that was made by the 10th District, and there's no support in the record to support that assertion. I agree that this case is unique because the 10th District has created a new class of damages based in tort to fill in a perceived gap in SMACRA. Preventive damages are not recoverable under Ohio SMACRA, and what the 10th District has authorized is that you can recover preventative costs as damages prior to showing any unlawful act that caused the damage. There's no basis in Ohio law for that proposition. And that's what's so dangerous about this 10th District opinion, why it extends beyond the specific facts of this case. Ohio SMACRA is not a remedial provision. Nowhere in Ohio SMACRA will you see the word remedial. That's a lawyer's argument. Ohio SMACRA has specific directions and specific remedies that I would encourage and argue that the court should follow instead of what the 10th District did, which was to create new damages that they prefer based on what's actually written in the law. No court anywhere in the United States has ever awarded damages for preventative measures that precede a legally recognized harm. And it's completely lawful to mine and subside the surface. Thank you.
Thank you. Thank you, gentlemen. We will take the matter under advisement and you'll be notified of our decision.
Thank you.
Our next case is 2019-1104, State of Ohio versus James Gideon. For the appellant, Mr. DiPietro.
Yes, ma'am.
Yourself? Okay. Proceed.
Oh, thank you. Madam Chief Justice, may it please the court. My name is Anthony DiPietro, and I represent the appellant cross appellee, in this case, the state of Ohio. The issue before this court regards whether a non-government employee gives a statement to an administrative board licensing agency governed by the state, and when there is no threat of loss of employment or removal from office, then that statement is not subject to Garrity v. New Jersey, United States Supreme Court case 385 U.S. 493. Garrity stands for the general proposition that when the accused stands for the unlawful imposition of any sanction which makes an assertion of the right not to answer an incriminating question costly, then that statement cannot be used in a subsequent criminal proceeding. The facts of Garrity pertain to police officers who were investigated for fixing traffic tickets. Each was given 3 warnings. 1, that anything that officer said could be used against him in a criminal proceeding. 2, that officer could refuse to answer an incriminating question. And 3, that any officer who refused to answer a question would be removed from employment. So as you can see in the case of Garrity, there was a direct threat that if that officer refused to answer a question on the grounds that it would tend to incriminate them, then they could be removed from their employment. So that created the quote classic penalty situation whereby the officers had to choose between the whirlpool and the rocks in the metaphorical sense. The United States Supreme Court held that the protection of the individual under the 14th Amendment against coerced statements prohibits use in a subsequent criminal proceeding of statements obtained under the threat of removal from office, and that it extends to all, not just police officers, but all members of a body politic. Since the ruling of Garrity, there have been other cases that have interpreted Garrity. And in fact, this court has adopted the two-part test in Graham that was first offered in the federal case of Friedrich. That two-part test stands for the notion that if an accused is put into a situation where they are to, if an accused is asked a question that there could be a benefit, or excuse me, a detriment to their employment, and if they have a subjective belief that they will face a sanction or a consequence for their employment, their livelihood, their reputation, or their professional standing, and then if that subjective belief is objectively reasonable, then that statement can be under the prophylactic rule of Garrity.
Well, isn't that exactly what happened at Murphy? I mean, isn't this case pretty close to Murphy? I mean, you talk about Garrity, but Murphy seems Supreme Court case that's pretty close to on point here. I mean, other than being a parole officer, I mean, what's the difference?
The cases that have come since Garrity, its progeny, there's either one of two distinguishing facts or both. One is that there was a direct threat, an express threat of penalty, which is not present in this case, or two, the investigation, the questioning was so intertwined with actual agents of law enforcement. And Murphy, as you stated, Justice DeWine, Murphy was a probationer, and he knew that his refusal to answer questions truthfully could implicate could cause problems with his probation, and he could end up sanctioned under those. The state of Ohio also submits that under the facts of this case, the investigation that was done by Investigator Yoakum, duty to cooperate does not necessarily mean a duty to answer the questions truthfully. Dr. Gideon even testified that had he had any idea that the statements would have been used by law enforcement, then he would have exercised his Fifth Amendment rights. I would argue that Dr. Gideon could have cooperated by simply stating to Investigator Yoakum that he did not wish to be interviewed that day, or that he would wish to have legal counsel present. He wasn't precluded from doing that. That would still be cooperating with an investigation. It's only when
isn't the salient fact here that Investigator Yoakum knew before he approached Gideon, he knew what Gideon had said to the investigative officers when he waived his Fifth Amendment rights, and he had denied all involvement. So here he is with an additional leverage of employment, asking the same questions. Doesn't that make him intertwined with the police investigation, as you mentioned?
I would argue that no, Justice, with all due respect, Investigator Yoakum was not intertwined. They were acting independently of each other. They admittedly, as it is known in the record, Investigator Yoakum did meet with Bluffton Police Department and did have conversations. But when Investigator Yoakum took the stand and said words like, quote, joint investigation, or he talked about the bootstrapping technique, these are terms of art that Investigator Yoakum didn't realize that he was using them improperly. Here, there was no joint investigation in that Bluffton Police Department was not present when Investigator Yoakum questioned Dr. Gideon. Furthermore,
Counsel Yoakum knew what the doctor's statements to the police officer were before he interviewed Gideon, correct?
Yes, ma'am.
All right, and so he goes in and he tells the police officer, hey, now in my role as an investigator for the board, I'm going to go in and talk with him don't show up. You shouldn't be part of this. And quite frankly, I don't know that the officer had any right to be there at the time. Correct? Is that correct?
Correct.
Okay. So there is an orchestration. There is a working together of both the investigator and the police officer prior to the interview, right?
Well, Your Honor, with all due respect, I would say that they are permitted by statute under Ohio Revised Code 4731.22. The investigator and the police are allowed to share information. So there was only orchestration insofar as they knew they would share the information with each other.
And they did share the information both pre and post interview by the investigator, Yoakum.
Yes, ma'am. But as I stated, 4731.22 has never been deemed to be unconstitutional. That statute gives the express permission for the medical board and law enforcement to share information with each other, with each entity through the course of their independent investigations. And that is what happened here. Yes, ma'am.
Okay.
With that said, the trial court determined that Dr. Gideon did have a subjective belief that he faced sanction. And in fact, the appellate court even agreed that that was a proper finding. However, where the third district erred was when they said that Dr. Gideon's subjective belief was objectively reasonable. The state of Ohio submits that Dr. Gideon's subjective belief was not objectively reasonable, in great part due to the fact that there was no high degree of collaboration between law enforcement and investigator Yoakum, other than the sharing of information, and also because there was no direct threat or even implied threat of any sanction. This isn't close to a case cited by the defense of Stubblefield, where there was law enforcement and an investigator alternating their questions at the same time. This also isn't a case like Friedrich, where the FBI agent was given an admonishment form, which clearly stated that sanctions could be a consequence for failure to answer truthfully. None of that is present here. In fact, Dr. Gideon was at his own office when this happened. He was on his home turf, and the facts point to there being no actual coercion or duress on the part of investigator Yoakum to elicit any types of statements whatsoever from Dr. Gideon. And with that said, if it pleases the court, I would keep the remainder of my time for rebuttal. Thank you.
Thank you. Mr. Belli. You'll unmute your microphone. There you go.
Can you hear me now, Chief Justice? Okay, I'm
Yes.
sorry. Well, may it please the court, opposing counsel, my name is Dennis Belli. I represent Dr. Gideon in this appeal. Starting point is the Fifth Amendment, which provides that no person shall be compelled in any criminal case to be a witness against himself. The key word is compelled. Fifth Amendment deals with compulsion. And I think a good starting point is the United States Supreme Court decision in Spivak versus Klein. This was a companion case to Garrity versus New York. It involved an attorney. The Supreme Court stated the threat of disbarment and the loss of professional standing, professional reputation, and of livelihood are powerful forms of compulsion to make a lawyer relinquish the privilege. We would submit that philosophy applies with equal force to all professionals, including medical doctors. We submit that this case is not about putting unwarranted restrictions on legitimate disciplinary investigations. Rather, it's a story about a rogue investigator who leveraged his
Let me ask you, how is this case different than Murphy?
Well, Murphy dealt with a probation officer interviewing her probationer. and there was no evidence whatsoever of any collaboration between the probation officer and a law enforcement
collaboration
agent.
doesn't have anything to do with the Garrity test. Collaboration might have something to do with whether or not Miranda rights are required, but doesn't have anything to do with the self-incrimination.
Well, in Minnesota versus Murphy, the court stated that an ordinary probation meeting to discuss routine matters pertaining to supervision does not give rise to the self-executing privilege. However, at page 435 of the opinion, the court stated, the result may be different if the questions put to the probationer, however relevant to his probationary status, call for answers that would incriminate him in a pending or later criminal prosecution. And I would submit that that language in the opinion forms the basis for this line of cases that looks at the degree of involvement of the questioner in the criminal process. In State versus Graham, this court adopted the objectively reasonable subjective belief test. One component of that is the statute. Is there a statute that extracts a penalty for exercise of a Fifth Amendment privilege? And in this case, there's the Medical Board 473122 that requires cooperation by licensed professional doctors, and there's a penalty up to revocation of the license for violation of that requirement.
So does that mean, do you think that, does that mean that in every case where there's a medical board investigation, that anytime a doctor would then be questioned, that we would always have to say, because of this threat out there, the statements can't be used? That's my concern with how far your argument seems to be going.
Yes, Justice French, and the third district was concerned about that. What they said was that the existence of this statute is, quote, one piece of the puzzle. They said that the other piece of the puzzle required to be examined under the totality of the circumstances test is the process. That's the word that they used, of the medical board investigator. Did the process in this case exceed the ordinary pressure in general under the statute to cooperate? And
So
the court stated yes.
Let's talk about the process then. You called this investigator a rogue investigator. So what are the circumstances that you think, what did he do wrong? What did this investigator do wrong?
He made a deliberate effort to involve himself in a criminal investigation.
Well,
And
but that's not really the coercion, is it? I mean, what I'm looking for is, what did he do when he showed up at the office? Should he not have shown up unannounced? Is that part of the compulsion? What was it that made your client feel compelled to cooperate?
His entire approach to the investigation, he did not approach it as an investigator for a professional licensing board. He stated to the police sergeant, and it's embodied in a written report, that after learning that Dr. Gideon had told the police investigator that he denied any inappropriate conduct, Mr. Yoakum told the police sergeant, well, I'm going to go talk to him. He has a duty to cooperate with me. And that's certainly, there's that implication there that he's going to leverage his ability to force Dr. Gideon to cooperate to get him to admit to criminal conduct.
But how can that make your client feel compelled if your client didn't know about that?
Because of the approach that he took during this interview. It's recorded.
I'll let you talk about that then. Tell me what happened once he gets to the office. What is it that he did wrong, the investigator?
Well, of course, number one, as you indicated, he arrives unannounced, and he admitted that his intention was to catch Dr. Gideon off guard and to get the truth out of him. This is Yoakum's own testimony. He shows up with a recorder secreted on his person. And that's awfully sneaky for someone who's employed by a professional licensing board, highly unprofessional. And the third district made a point in one of the footnotes that we have a statute that requires the boards to adopt regulations to govern the behavior, the conduct of their investigators. And from their research, the board never adopted any such thing. And Yoakum gave equivocal testimony about his authority for doing this. He said a lot of investigators do it, but he admitted that he wanted to catch Dr. Gideon off guard. He felt if he showed him the recorder that he would be more guarded in his responses. And he admitted in a response to my question that's exactly what criminal investigators in drug cases do. It's just the entirety of his behavior. He said, the recording shows that he used a number of intimidatory tactics. He told Dr. Gideon, I don't want to drag you through the mud by interviewing other patients. I don't want to put doubts in their mind. Again, more consistent with the criminal investigator approach. He told Dr. Gideon, I can tell from body language whether you're telling the truth. He said, hey, he pretended like he was just dropping in for a quote chat, but then he told Dr. Gideon, hey, I don't want to come back here for more answers, showing frustration that he wants.
Counsel, Dr. Gideon was aware of the allegations, correct?
In general, yes.
Well, all right, he was interviewed already by the police.
Correct.
So he knew there were allegations by patients that he was inappropriately touching them.
Yes, Chief Justice.
Okay, it wasn't a mystery why the investigator was there talking to him.
Well, he knew that he was there for a disciplinary investigation.
All right, and he knew he had an obligation to cooperate. He could have lied to the investigator, and that still would have been, at least in the short run, he couldn't have been, docked for not cooperation, right?
Well, there's the requirement of
I know, truthful
truthful answers, yes.
Right, but okay, so that is, the fact that he could lose his license if he doesn't cooperate, you're saying drove him to be truthful with the investigator and was more powerful than being truthful with the police officer.
No, we submit that he was truthful with the police officer, but that this investigator used a number of tactics to extract a false confession. And something that doesn't appear in this, in the opinion, because it has more to do with the trial itself, is that an expert testified for the defense and pointed out a number of tactics that the investigator used in an effort to extract a false confession. He talked about confession and reconciliation. It's got to be remembered that the context of this was that Dr. Gideon he was 70 years old, had practiced a long time. He was experiencing adverse health. He did not want to cut back on the number of patients he was treating. His staff was concerned, and he failed to explain to some of his patients this massage technique that he had learned to make these painful injections a little more comfortable. And what this investigator was doing was twisting things around in order to get Dr. Gideon to say that, well, maybe I had a motive of gratification. And it was the investigator that injected this term into the conversation, gratification, which is the key term in a prosecution of a medical professional for sexual imposition, because a medical professional, especially a rheumatologist, is going to be touching parts of the body that are otherwise considered erogenous zones, and his guilt or innocence of the charge of sexual imposition turns entirely on the question of whether there was a motive of sexual gratification versus legitimate purpose in diagnosing and treating the patient. So we would submit that, he told Dr. Gideon that he accused him of trying to get away with it. He warned him that there could be falsification charges. He instructed Dr. Gideon, go back to the police department and correct your statement. He encouraged him to air it out, clear your conscience. He told them that he must be accountable. I doubt that these are the normal techniques used by a medical board investigator to basically get the information he needs to report back to the board and make a recommendation. So was there compulsion within the meaning of the Fifth Amendment? I think the Third District got it exactly right. They wrote a thorough 40-some page opinion where they addressed every point that the state is trying to claim here. Just like at the appellate level, the prosecutors trying to pretend, oh, this is just a question of that a statute requires the sharing of information, nothing more than that. The medical board investigator was a straw man, a stalking horse, and this court has to ask whether this type of behavior can be sanctioned. And I think a reversal of the Third District opinion basically gives licensing board investigators a go-ahead to engage in this behavior. And to me, it's just awful. And so we would ask that the court affirm that portion of the ruling. I have about a minute left. I'll address the cross appeal very briefly. And that's this question of whether a court of appeals must, under what circumstances must a court of appeals resolve other assignments of error. And we've proposed that if the error in question is likely to be repeated on remand, that the Court of Appeals should conserve judicial resources and address them there. And certainly with respect to any claim that there was insufficient evidence to support a conviction, we would submit that principles of double jeopardy require the Court of Appeals to address that issue, because if the evidence was insufficient, there's no reason for a remand. And we did challenge the sufficiency of the evidence with respect to one of the alleged victims, because everything she described, taken at face value, did not support the charge in question. That concludes my my argument. I see my time is up.
Thank you. Counsel, you have 5 minutes and 46 seconds left.
Thank you, Madam Chief Justice. Justice French, to your point about whether or not this case or cases like this can create a slippery slope, I would acknowledge that the case law makes it clear that ordinary job pressures do not apply. In a situation where there's alleged misconduct on the job, an employer or a licensing agency can always go and ask questions that are germane to that alleged wrongdoing. And that's all that investigator Yoakum was doing here. So the state would submit that this was just an ordinary job pressure that does not require suppression of his statements.
What about the secret recording? How would you address that?
To the state's understanding, Justice French, such a recording is lawful in the state of Ohio so long as one party is aware of a recording. It's used in interview I would submit that many of the tactics that Yoakum used are just common interview tactics. that are used in any course of any investigation or of any fact gathering. And I would say that that recording just falls under an umbrella of proper investigation tactics.
What's your response to your opponent's argument about Spivak and how it's parallel between a lawyer and a doctor?
The cases were at different stages of what was being looked at. In Spivak, the accused there failed to respond to a subpoena ducis tecum and failed to testify. Here, if Dr. Gideon didn't want to answer Investigator Yoakum's questions, all he had to say was, I would like to consult a lawyer, or I would like to have a lawyer present. That would be a truthful answer to a question of that would be posed by Investigator Yoakum. So this was far earlier in any proceeding or investigation than when Spivak was analyzed.
Then why show up unannounced? Why not call him ahead and say, hey, I'm coming over?
So with all due respect, Justice Fisher, again, the state argues that's just an interview tactic. Investigator Yoakum was not prohibited from calling ahead of time, but he did go to a place of business, a doctor's office that is generally open to the public, or at least to patients, during regular business hours. And he did ask permission to speak with Dr. Gideon. I think that his direct quote was he asked him if he had a few minutes to talk. And even at that point, Dr. Gideon could have said no, but instead he agreed to speak with him on that time. So I would compare it to I don't want to get too into this analogy, but it would be comparable to a consensual encounter with law enforcement. Gideon agreed to meet at that time. Going on to the cross appeal issue, all of the arguments raised by defense counsel are speculative from the state's perspective. What trial tactics or questions that have...
What about the double jeopardy claim? That's not speculative, is it?
With all due respect, Justice DeWine, I understand your point about not being speculative. Here we have a situation where an appellate court ruled that certain evidence should have been suppressed, should not have been used at trial. However, that evidence at that time was properly before the jury and considered by the jury.
I understand that, but why wouldn't the appellate court consider all the evidence and look at the sufficiency claim? Because it's certainly not moot, because if the court had considered that assignment of error and found the evidence was insufficient, he couldn't be retried.
Appellate courts give great deference to the jurors or to any trier of fact, whether it be a bench trial or a jury trial. I understand that. The standard's not the question. The question is whether it's moot. And the state of Ohio submits, Justice DeWine, with all due respect, that the proper procedure is to remand for a new trial, because we don't know why the jury
not on an insufficiency claim.
With all due respect, Justice Stewart, wouldn't then an appellate court be looking at a record that was not the entire record before the jury?
Well, I think the court would have to look at the record, the entire record, before the jury. I agree with you that the court shouldn't do what defense counsel says and excise what the court found was impermissibly admitted from the record, but shouldn't the court still consider the sufficiency claim just like what happened in a federal court?
I would submit, Your Honor, or excuse me, Your Honor, that the appellate court, to say that certain evidence should have been suppressed and then to go ahead and make a ruling determining.
Well, why shouldn't it have done the sufficiency first then?
Judicial discretion, Your Honor.
Well, but I mean, the rule says that unless an assignment of error is moot, the Court of Appeals has to consider it. And if ruling on the assignment of error could result in the fact that he could not be retried again, it doesn't seem like it's moot, is it?
He could be retried, Your Honor, but again,
it couldn't be retried if the court found the evidence was insufficient.
Oh, excuse me, I misspoke. I'm sorry, Justice, I don't understand your question.
Well, I don't understand how it could be moot if a ruling in the defendant's favor on that issue would prevent him from being retried.
Well, just to state it simply, Justice DeWine, it's moot because another dispositive assignment of error was determined. And that was sufficient
But that assignment of error was not dispositive of whether or not he could be retried again.
Yes, sir.
The ruling in his favor on that assignment of error got him a new trial, but a ruling in his favor on the sufficiency assignment of error would have precluded him from being tried. So it's hard for me to understand how it could be moot.
I respect your position, Justice DeWine, but it's a question of having an appellate tribunal sit as a fact finder.
That's not the question, right? When an appellate tribunal rules for sufficiency, they don't sit as a fact finder. They say, could any reasonable jury have found that this evidence is sufficient to each one of the elements of the crime?
Well, there's other evidence presented at trial, including the credibility of the witnesses that an appellate panel cannot view and cannot determine.
Right, but appellate courts review on sufficiency arguments all the time, right? So
based off of testimony and other evidence submitted. Here, if you exclude certain testimony or certain evidence.
Why would they exclude that testimony? Why wouldn't they just rule on the sufficiency assignment of error?
Because in the record in this case, Justice DeWine, part of what was to be suppressed was Dr. Gideon's statements that he did commit wrongdoing.
But on the sufficiency claim, the court has been pretty well established in our precedent that a court considers all the evidence, not just evidence that should have been excluded.
Yes, sir.
Okay. Another question?
I'm finished.
Counselor, you've used your time, so we're going to conclude here.
Thank you.
All right, thank you, gentlemen. We will take the matter under advisement and be notified of our decision.
Thank you.
Marshall, will you adjourn, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.